Hi, everyone. Thanks for joining us for our webinar today with Orr Reno. I'm Emily Marsh from the Greater Concord Chamber of Commerce. I just want to let you know that if you have further questions after the event today or on different COVID topics, you can go to the Chamber's website, which is concordnhchamber.com. From our homepage, you can quickly click on our COVID resource page. From there, we have tons of links that we update basically daily, resources for business owners, people in our community that are looking for answers right now. So please check that out. We are also recording today's webinar, so that will be sent to you after the event, as well as a copy of the PowerPoint slides. So keep your eye out for that as well. If you have questions today during the event, you're going to want to submit them through Zoom's Q&A portal. So to access that, you're going to tap your screen or just move your mouse a little bit, and you'll see this button called Q&A. From there, you can just type in your message. And those questions can only be seen by the host or the presenters. So it will not be seen by the other attendees. You can type in your questions there, and we will have access to them. I do want to let you know about another Chamber webinar coming up this week. On Thursday at 1 p.m., you can join us for a webinar with Mainstay Technologies. They are going to be talking about remote workforce, keeping a great team environment that's productive and communicates well, even though we're all not in the office right now. So that's going to be a really good presentation. They are a great business to work with. Before we kick off, I just want to thank Orr Reno again for their great presentation today. They're actually sponsoring this series of webinars with us, so thank you so much to them for doing that with us and sharing this great information with our members. So with that, I'd like to introduce our presenters today. Thanks for joining us today.
Good morning, everyone. I'm Lisa Wade at Orr Reno, as you just heard. And the topic we're going to touch on today is how the pandemic is affecting contracts. Can you terminate or excuse performance under a contract because of the pandemic? And let me push this down. Here's the basic three topics that we're going to be covering. First, we're going to take a look at the legal theories that may excuse performance or permit an actual termination of the contract altogether that are recognized under New Hampshire law. And quite frankly, virtually every jurisdiction in this country and most of Western Europe and other countries whose law is based on them. We're also going to look at pitfalls that you need to watch out for if you're going to invoke one of these legal theories to the other party in your contract to try and excuse your performance or terminate. And finally, we'll take a look at strategies and other considerations that you want to think through before you either seek to invoke one of these theories to terminate or excuse performance. And if you, for whatever your circumstances are, really don't have a basis to invoke one of these theories to affect your contract, is there a plan B? Is there some sort of negotiating strategy that you can employ that might get you to the same place? So that's the basic three. Let's go first to the legal theories. I'll outline them first, and then Bob and I will lead you through the basic idea for each of them and the types of circumstances that they might apply in. And obviously, the COVID-19 pandemic is where we're going to focus our examples so that you can, maybe assess whether your own contracts can be or will be impacted by any of these legal theories. First off, the word of the day is force majeure, and those are clauses in contracts. So we'll talk about what that is and when it applies. Then there's three common law theories. Common law means that the courts have developed these theories even though parties didn't necessarily put them in a contract. And those are commercial frustration, sometimes known as frustration of purpose of a contract. And then there's impossibility of performance and impracticability of performance. And we should note right from the outset that none of these four legal theories are designed to get you out of a bad deal. They're not a get out of contract free card simply because you don't like the deal you got and now you're using the pandemic as an excuse. The pandemic has to actually impact significantly on the contract. And likewise, if your business has slowed down because of the pandemic and you're short on cash, that is not a reason to invoke one of these theories. So simple inability to pay isn't what these theories are trying to get at. So with that, let's start with force majeure. It literally means superior force, and it's designed to address risks that the parties negotiated into a clause in the contract that excuses performance or perhaps terminates the contract altogether if one of these very significant events happens. I can tell you that they're interpreted strictly because they're contractual provisions that limit the party's ability to, or the party's obligations to perform under a contract or permit termination altogether. If your contract does not have a force majeure clause or some kind of a clause that allows the parties to get out of the contract or excuse performance if something significant happens, you can't use this theory. It is a contract term. I've given down at the bottom of this slide an example of an actual force majeure clause that was in a contract that I dealt with recently. And the things that you want to look out for in these clauses is, first off, does it apply to terminate a contract, or does it also address delays in performance? Because in the COVID situation, right now, I suspect there are many contracts that have delayed performance. You can't do whatever the parties intended right now because of the executive orders limiting what businesses can do, or restrictions that the CDC has recommended in terms of getting people in locations and so forth. So there might be a delay in performance, but there might be an absolute inability to perform because, let's say, you had a contract for a wedding to be held in the month of April at a particular venue. April's come and gone. Nobody could go to that wedding. Force majeure might apply if the type of event here, a pandemic, is anticipated by the parties as falling within force majeure. So look a little farther down in this clause, and you see that in this particular one had to do with a contract for a meeting space. It talks about acts of God, war, civil disturbances, accidents, labor disputes, but excluding if you're booking your meeting for a third party, a cause within the third party's control. So act of God, different states interpret that term differently. Acts of God are usually considered natural events like tornadoes, hurricanes, volcanic eruptions, for folks that live near a volcano, Hawaii or Mount St. Helens kind of situations. Pandemic is not listed here. And it's sort of interesting that some contracts started adding pandemics after the SARS epidemic in the early 2000s. So the fact that pandemic is not in this list might be a problem if a court is interpreting each of these terms very strictly and says, well, we're not going to interpret a pandemic as an act of war. We don't know yet whether the New Hampshire Supreme Court would take that view, but I can tell you in some jurisdictions outside, other states that I've researched recently, they would not interpret a pandemic as an act of God. So it really kind of depends. This provision doesn't have any sort of broad language that might suggest other terms. So this force majeure clause might create a problem if you're trying to assert something related to the pandemic. Here's another one that I wanted to show you, and a charter contract. It was part of the same issue that I was looking at for a client who was supposed to be traveling to Florida for a meeting at Walt Disney World using a charter airline. This charter airline is much broader. This force majeure clause in this charter contract was much broader. It defined, and I'm coming down here, if you can see my cursor, force majeure shall mean any event which is not reasonably within the control of the parties. Much better language to invoke if you're trying to use the pandemic as the reason for the force majeure here. Not reasonably within the control of the parties. That's pretty much standard. If something happens that the parties anticipate will happen, that's really not a force majeure event. That's a risk that the parties reasonably should anticipate and deal with through contract terms like the price or whatnot. It says, including but not limited to acts of God, strike, lockout, other industrial disturbance, act of the public enemy, war, blockade, public riot, lightning, fire, storm, flood, explosion, governmental restraint. That's an important one right now, and any otherwise. That's the kind of clause, if you have it in your contract, that's going to be much easier to fit a pandemic excuse into, particularly the governmental restraint, because a lot of what's affected business contracts right now is the executive orders and the presidential orders that have restrained businesses from participating in their normal activities that will be affected by these contracts. Frustration of purpose is a common law concept that gets you the same place essentially as a force majeure clause if you don't have one in your contract. Even if you do, though, you might want to assert force majeure and one of the common law theories, this one or one that, of the two that Bob will be talking about shortly, as your justification for getting out of your obligations under a contract. It's considered what I would call a gap filler because it's designed to hit situations where the parties didn't include a force majeure clause or didn't include the type of risk like pandemic that easily fits within the force majeure clause. And you're looking at kind of the overall fairness of the situation if the parties are severely impacted by something like a pandemic. Frustration of purpose exists if circumstances essentially destroy the reason for a contract due to no fault of either party. And I'm going to distinguish reason for a contract from the ability to perform a duty under a contract, because that's really the subtle distinction between these different common law theories. Frustration of purpose gets at the reason for a contract. And it anticipates that the parties might literally be able to perform under the contract, but the reason, the reason that both parties understood the contract to be for has now been destroyed. If we get back to my example of traveling with your group to Florida for a business meeting at Walt Disney World, we've got executive orders in Florida that close the Walt Disney World theme parks. You could argue that there's been a frustration of purpose because both parties, the resorts at Walt Disney and the group that was paying to go have their business meeting in Florida, understood that the reason they picked that venue was so that the group could enjoy the theme parks as a recreational activity in conjunction with their business meeting. This would be the kind of situation where you could invoke frustration of purpose. It's not that the group can't pay for the rooms, and let's assume that the hotels were still accepting people and were not themselves closed for purposes of this example. So they could supply the rooms, the party could pay for the rooms, but they can't enjoy the theme parks. That's the point of the contract. The parties understood this. Frustration of purpose applies. I'm going to turn the microphone over to Bob now to talk about impossibility of performance.
Good morning, everybody. My name is Bob Carey, and like Lisa, I'm a lawyer in the trial practice group at Orr Reno, and I want to thank Emily and the Chamber for helping put this on. I see that we've got one question now, but we'll hold questions to the end so we can get through this materials. So the second, Lisa talked about a contract way of, or a contract that addresses an unexpected event like force majeure. Frustration, which Lisa talked about, and then the two things I'm going to talk about, the doctrine of impossibility and also impracticability, are all about stuff that happens that gets in the way of your contract that nobody thought was going to happen. Nobody planned on it. So the first one is the doctrine of impossibility, or the impossibility of performance. And it's pretty straightforward. As I've got on my on the screen that you can see, it's got three things. There's something that everybody's counting on as part of the contract. Something unforeseen happens to that thing. And as a result, it's impossible to do this contract. So you look at, what were you counting on? What happened? Was it a meteor hit, or was it something that you caused? And did it make the contract impossible to perform? And I'll give you an example. I'll give a couple examples that are non-sort of COVID examples. And the first one would be a painting contract. So a house painter's got a contract to paint somebody's house by April 1st, and the house burns down. So there's no house to paint. It's impossible to paint this house because it doesn't exist anymore. That's an example of impossibility. You're expecting the house would be there. Something happened, it burned down. So now you can't do what your contract required you to do. Under those circumstances, the painter would be let off the hook. He'd be excused from performing the contract. Now, another scenario, and this I think is to sort of emphasize the unexpectedness, the unpredictability of what happens, would be, say that the painter is supposed to paint the house by April 1st. The painter gets a DWI. He can't drive. He can't get his truck to the job site. That's certainly unexpected, but he's to blame for it. So he can't use that as an excuse to not perform the contract. There's also, his DWI doesn't necessarily make the contract impossible to perform, because he could hire somebody to drive him there, or find another way to get to the job site. So that's a situation where it may have been unexpected, but it was somebody's fault. In this case, the painter's fault for getting a DWI. Now, let me give you sort of a pandemic example of impossibility. Say the painter's job, the contract calls for the painter to paint the house by April 1st, and you've got a stay-at-home shutdown order in place through June. So you've got everybody assumed that the house would be there. Everybody assumed that everybody would have access to it. Now something unexpected has happened. You've got a government order saying you can't do this. And that's not something anybody could have predicted, or that it was anybody's fault. And as a result, doing that job by April 1st is impossible for the painter. So he would be excused under the contract from performing this contract. So Lisa, why don't we go to the next slide?
Okay.
So this is part 3 of sort of non-contract based things that are legal theories that allow people to sort of adapt to the situation. The first one was impossibility. So something happens that makes it impossible to perform the contract. The next one is this impracticability of performance. So it's basically, it's very much the same, but so you had something that you were counting on to be part of the contract, something unforeseen or unpredictable happens that is nobody's fault, and now as a result, it's impractical to perform the contract. Not totally impossible, but it's not practical to perform the contract. Usually this involves costs and supply and that kind of stuff. But I'll give you an example from a court case. and this is down in Boston. And the general contractor was hired for a road job, a highway job on 128. And part of the job required the general contractor to put concrete barriers down the middle. The neighbors to the project complained about the increased noise from the concrete barriers. And so they sued, and as a result, the DPW said, okay, no more Jersey barriers. Now, the general contractor had hired a sub who was going to supply all those Jersey barriers. The sub, halfway through the contract, these Jersey barriers aren't part of it anymore. It's not practical for them to provide these Jersey barriers because they're not part of the contract anymore. I'll give you a sort of a pandemic example of impracticability. As I mentioned, it usually affects supply and cost. So say a food supplier has a contract with a restaurant to provide beef at a certain price. As a result of the COVID-19 situation, the food supply chain has been seriously affected. You can't get people to work on the farm. You can't get people to process the beef, and there's also as a result there's a shortage of beef nationwide. So as a result, you can get the beef, but it's going to cost you 10 times what it was going to cost you initially. So there's no way you can perform the contract at the same price you were going to sell the beef to the restaurant for. It's no longer practical because the cost has gone through the roof for a reason that nobody predicted and nobody was at fault for. So that would be an example of a contract becoming impractical to perform. Right. I think next Lisa's going to talk about some of the pitfalls and the steps that you need to take when you invoke or when you use one of these theories to try to be excused from performance of your contract. Lisa?
Okay. And I've labeled this pitfalls based on my experience in dealing with the travel contract that I've been using as my main example, a business meeting to be held at Walt Disney World in Florida. The law that applies to your contract, first off, is one of the important considerations. We've been talking about these topics primarily from the perspective of New Hampshire law. And as I stated at the outset, most of the states in the country recognize these four theories, or they may merge a couple of them together and treat them as, kind of, they could say impracticability and impossibility are kind of the same thing, but a question of degree, so there's some states nuance it a little bit, but these same four theories basically are recognized. But it's important to know, like in my travel contract situation, the law of Florida applied. So it was important for me to see how the Florida courts have interpreted force majeure clauses and these common law theories so that we invoked them appropriately, so that I didn't do something that was wrong. The other thing that you want to be very careful about is how you term what you're doing. Are you canceling the contract? Are you terminating the contract? Are you excusing performance? And why does it matter? Many contracts have cancellation provisions. It's a term of art that's used in the contract. So if you say, yeah, I'm canceling the contract because of the pandemic, the hotel in Florida could say, wonderful, the cancellation clause requires you to pay 70% of the full contract price. Please, we'll remit the other amount of the deposit. What we wanted was to excuse all our performance to pay for the business trip and get all the money back. Therefore, we had to be very, very clear that we were invoking the force majeure clause and the doctrines of frustration of purpose, so that it was clear that we were asking for all the money back and that we were not planning on showing up in April to the business meeting. And there was some dancing back and forth from the other side saying, okay, so you're canceling the contract. No, we're terminating the contract by invoking the force majeure provision and the common law doctrine of frustration of purpose. We had to keep making it clear so that the ball didn't end with us agreeing that, yes, we're invoking the cancellation clause, which had substantial financial penalties associated with it. You also want to give prompt notice so that you're not causing more harm by stringing the other side along for a period of time and have them claim that you simply breached the contract, and after the fact you're trying to invoke the pandemic as an excuse. So prompt notice is one of the things that the courts look for when you are trying to get out of a contract because of one of these theories. So the event happens, the pandemic, and then you want to promptly notify the other side that you can't perform because of the pandemic, or you're invoking force majeure because of the contractual term in your contract. If you breach the contract prior to, in this case, we're talking about pandemic, so you are already in breach of contract, these theories are not going to get you out of a claim for breach of contract. So the courts aren't using this as a, they call it get out of the contract free card. If you breach the contract, you breach the contract, and you could be liable for damages as a result of that. So the takeaway here is be careful, do it in writing so you have proof that you are invoking force majeure or frustration, impossibility, or impracticability, and be definite that you're requesting that performance be excused, or you're trying to terminate the contract so that it's clear. There will be situations where a just suspension in performance for a few months makes perfect sense, so that it may be that you don't have enough to justify complete termination of a contract, but the pandemic may provide you with an excuse for why you're 2 months late in performing under the contract because you haven't been able to get supplies or provide the workforce or whatever the subject of your contract is. So with that, I'm going to turn it back over to Bob to discuss some strategies for either invoking these theories or not, if you can't, or whether you should.
Sure. Thank you. And there's some questions that I've seen on impracticability and impossibility that I'll work into my answer as well. So there's three things you need to do when you think you have one of these situations. You've got to assess as the first step. The second thing is to communicate. And the third is usually to negotiate. All contracts are relationships. And most of them are long-term relationships that both parties have invested a lot in. And you need to assess whether you've got a situation that is a force majeure situation, a contract situation, or whether you've got frustration of purpose, impracticability, or impossibility. So you got to assess what you're dealing with here. Does it fit into one of those four boxes? Then you also have to assess, what do you want to do? It's contracts or relationships. Can you afford to pull the plug? Do you want to work with this other party that you've got a contract with? Are you invested in this relationship? Litigation can be expensive. So just because you may be able to invoke, or which is a legal word for use one of these theories, you may not want to. It may not be worth jeopardizing that long-term relationship, contractual relationship. So the second thing you want to do is you want to communicate. You got to talk to, as Lisa mentioned, as soon as there's a problem, you got to contact and communicate first with your lawyer to say, okay, what do we have here? But second, you got to contact that person you've got the contract with and let them know that there's an issue, or that there's an issue that you need to work out. The third thing is to negotiate. You got to assess, communicate, and negotiate. Because more often than not, there might be a way to save the relationship modify performance, extend performance. Um, and if you can maintain the business relationship you've got with that person, you should. You should. These aren't reasons to try to get out of contracts unless you absolutely need to have your performance excused because of something out of your control. So there were two questions, and I'll take the impossibility and impracticability questions first. The impossibility question was about the painter and the house burns down and there's no house left to paint. Clearly, the performance is impossible now because there's no house there. Both sides would be excused from performance. The painter doesn't have to paint a house that's not there, and the owner doesn't have to pay for a house to be painted that can't be painted. Especially if you look at if there's no fault of the owner in the house burning down, then the owner is also excused from performance too because the job is impossible to perform now. The question I got on impracticability was a sort of a COVID type question. And what Lisa and I are trying to do here is also give everybody sort of the general theories so you have some sense to it. You don't have to memorize every step of every theory, but it's just to give you a feel for sort of how the law views contracts when unforeseen things come up. So the question I got about impracticability was, say a performance hall, a theater had a contract with a band to sell so many tickets. All of a sudden, there's the COVID-19 situation, and the government says, you can't have as many people in a theater as you used to because you still need social distancing. So you can have, instead of 20 people sitting in a 20-row seat, or 20-seat row, that is, you can have 4 people sitting in that 20-row or 20-seat row. That would be a situation of impracticability. The contract, you can't sell as many tickets as you were obligated to before, and so your cost of performing that contract is dramatically gone up. So that would normally be a situation of where you want to look at that impracticability theory. And again, Lisa and I are trying to provide some sort of background on these theories. We're not trying to give case-specific legal advice. The purpose of these webinars is not for case-specific legal advice. But in any situation where you think you've got one of these things that's come up, again, you need to assess, you need to communicate, and then you likely need to negotiate to try to figure out a way, see if there's a viable workaround to preserve that relationship in some way. So Lisa, I think there were some questions on frustration and also possible force measure.
Yeah, just looking through these. Someone asks if, in the reverse of the painter example, if it's impossible for the painter to complete the work and is released, is the homeowner still obligated to pay? No. The contract becomes completely terminated, so everybody's obligations under that contract have been excused at that point. It's essentially the idea of rescission. Without, I don't think the courts would obligate the parties to put each side back in the position they were. A classic rescission situation under the law is that the contract is terminated as though it never existed. And if somebody had, for example, the painter had bought all the house paint to paint the house, he might be able to get reimbursed for that if you're rescinding. I think in the impossibility situation, they would not necessarily award damages to the painter from the homeowner to have to reimburse him for the paint that he bought. But he wouldn't have to perform the contract and paint the house, and the homeowner wouldn't have to pay the $10,000 that they contracted to paint the house or whatever the number was. And then there's a question: would frustration of purpose apply to a contract with an artist in a venue for the purpose of a concert because the audience cannot gather at all? That is a classic frustration of purpose. both parties entered into this agreement with the idea that there would be a concert on a particular day, that would be classic frustration of purpose, because the reason for the contract can't happen, even though technically the concert promoter would be able to pay and the musician would be able to come in and perform to an audience of 0 people. It's not impossible to perform the contract, but the idea here is it's performance art and there should be an audience to enjoy the performance. That contract has been frustrated. So that would apply in those circumstances. We also got asked if a civil disturbance listed in the force majeure clause would qualify as an event, given that the government has required business shutdowns. A civil disturbance would be something like a riot. So I guess if a riot occurred that somehow impacted performance of a contract, that could apply. People are rioting over COVID restrictions and wanting to get back to work and so forth. But it probably is not what you're getting at. The government action that is often listed in the list of force majeure events would be related to the government shutdowns, the executive orders. It would be sometimes known as civil authority or orders of civil authority. It's sometimes described that way. So the civil disturbance probably doesn't apply unless you literally have a riot and that is what's impacted your contract.
So just to recap, there are situations that come up, like the painter in the house that burns down example, that just do happen and they're not anybody's fault. There's also this kind of situation where there is a public health emergency and the government has taken certain steps to protect people and protect the common good. That's certainly an unforeseen event. And in a situation like this, it's affected everybody. So you have to see whether whether you want to use one of these theories to be excused from performance, whether you want to try to work with the other party to your contract to either put the performance off, delay it, change the price if you can, see what you can do. And you need to make sure that if you are going to try to be excused in performance of the contract, that you do it the right way. And that's where talking to a lawyer is a good idea. So you know how to invoke these theories, how to use them, what language to use. You know how to communicate it. It's important always when you have a problem with any contract to give quick notice so the other side doesn't has a chance to sort of sort it out or adapt to it. So I hope some of these examples were helpful, and I think these questions also came up with some very good examples that are also sort of pandemic specific. So again, hopefully these theories are useful and might even be useful in times not related to a pandemic. And if there are any other questions, we're happy to take them.
One example that I think we should probably touch on are leases. People don't always think of a lease as a contract, but it is, just like many other agreements between parties. It doesn't have the word contract at top, but a lease is a contract. And we've had questions from landlords and tenants as to whether they have to pay their lease payment, either because their business is shut down, so they are not bringing in any money, or they can't get, you have a contract, for example, with your gym. You've got Planet Fitness or something, and they're drawing money out of your account, and they are, you can't get to the gym, so you can't use any of the services. So there's different examples like that that might be useful for the folks to hear about. Um, and again, it depends on the nuances of your circumstances as to whether any of these theories might apply. Typically, the force majeure type events that affect a lease would be a fire, so that the premises are destroyed, or you're prevented from going to your premises because of an order of civil authority. That might be in a contract with a force majeure provision, but that's typically in the context of there's been some kind of an event that the government's come in and condemned, for example, a restaurant, and they've condemned the restaurant because of health code violations or something like that. I think those are the kinds of events that are anticipated typically by a lease, as opposed to a pandemic where everybody's ordered to stay home virtually. A force majeure clause might apply if you have some reference to civil authority closing the premises. The doctrines of frustration, impossibility, or impracticability might possibly apply, but I suspect it would be a harder sell if literally the problem is I didn't bring enough money in because my business has been closed and I can't afford to pay my rent. That is probably a harder sell. But if the purpose of your contract, like the things we've been talking about, your lease, for example, is, let's say you rented a space for a 1-month pop-up shop that you were going to sell items for Easter and Passover and some stuff that was happening in the month of April, and your shop got closed down. If the landlord and the tenant both understood that the reason for the lease was something that's can't go forward because of the pandemic, that might be an excuse, commercial frustration that would get you out of the lease. But simply, I can't afford to pay my rent probably is not an excuse that would get you into one of these theories. Any other thoughts, Bob, on using these theories?
I think that's it.
Okay. Final theory, final thought here before we go. If none of these legal theories apply, it still doesn't hurt to negotiate. You can negotiate forbearance agreements, extension of performance, offer new terms, any of those things. I think right now, particularly, landlords that want to have their tenants stay for the long term, recognizing that we'll be getting back to work soon, that might be open to these kind of ideas. So the kind of final thought is, don't give up just because you conclude that none of these theories apply. It never hurts to negotiate.
Right.
Okay.
All right.
This has been
Well,
helpful.
yeah, thank you for that great presentation, everyone. I'm going to take over screen share for a minute. All right, so I just want to let you know about a couple other things going on with the Chamber. Our Pinnacle Awards have been rescheduled to September, so you can actually nominate a Business of the Year, Small Business of the Year, Nonprofit of the Year, and Business Leader of the Year. So think about doing that now to support local businesses. We also have a Leadership Greater Concord program going on, and applications are open for that. I want to thank Orr Reno once again for this great presentation today and for sponsoring this series. Thank you both so much for sharing this information. It was really valuable. So again, this webinar is recorded and it will be sent to everyone afterwards, as well as a copy of the PowerPoint. So thank you for joining us, everyone.
You're welcome.
Thank you.